This is not getting discussed on the mainstream media. Not only are they wrong legally, but the fact that they would do this is outrageous. This is an overreaction and really nonsense. How would you react if this was your son or your daughter? It's the offense of knowing the truth. It's the offense of having an alternate worldview. Saying God bless you to someone is not a violation of the law. Well, welcome to the broadcast, everyone. It was 25 years ago, about 2 hours ago, that the Supreme Court of the United States issued its decision in Board of Airport Commissioners versus Jews for Jesus. It was the very first case I argued at the Supreme Court of the United States. Now, in those days, there were no internet. There was no instant communications like that. You actually had to call and get the opinion decision. I was in Moody Bible Institute's buildings in their campus in Chicago, Illinois, doing a training symposium for Jews for Jesus staff that were distributing religious literature and a summer witnessing campaign that were about to take place throughout the entire United States. I was doing a discussion about First Amendment activities, what you can and cannot do. We got word that decisions were coming down that particular day, June 15th, 1987. I went to remember these folks? Coin-operated phones, remember payphones? I went to a payphone. And you had to type in the number and then your credit card information, and then they answered the phone, the clerk office of the Supreme Court of the United States. And I said, has the decision come out in 86-104? That is Board of Airport Commissioners versus Jews for Jesus. The clerk of the court, Sandy Nelson, said, yes, it had come out. The decision is unanimous in your favor, 9-0. And I will tell you, that was a happy day, and it ended up becoming, of course, a life changer for me and my family. And Jordan was actually in the courtroom during that argument, or at the proceedings, has his picture in front of the Supreme Court of the United States, and it was not in the courtroom itself. It was right there on the steps of the Supreme Court all those years ago. I don't know if you remember much about that, Jordan. You remember the picture, that's for sure.
Yeah, we've got that picture everywhere, and you get to see the style of the 1987 Sekulow family. And
Yep.
I think there's all of us are in that picture. Yeah.
Why don't we post that up on our Facebook, and that'll be great. Let's get that picture posted, because I think Pam has that up on her Facebook. We'll get that picture posted on Facebook. Some of you may remember our days when I was with Jews for Jesus, or with the group Christian Advocates Serving Evangelism, which, of course, is still around. It's the parent company for the ACLJ. We're going to go down memory lane a little bit, talk about the decisions. This is the 25th anniversary for this decision. We're going to come back and play for you some of the audio from the Supreme Court argument itself. But what we're asking people to do today in honor of the 25th anniversary of this decision is to support the work of the ACLJ that's now going on, not just here in the United States, but around the globe, with a donation of $25. Because it is the 25th anniversary for the case. Jordan's going to give you the information at aclj.org and the phone number, but we sure would appreciate you standing with us, and now our hundreds of lawyers around the world standing for freedom and liberty.
Call now, 877-989-2255, the 25th anniversary, asking for a $25 donation. Call now, 877-989-2255 to support the ACLJ.
It was a resounding win for free speech and religious liberty. 25 years ago today, the Supreme Court, in a unanimous decision, agreed that religious speech must be given the same protection as all other protected speech. It was the first of what would be many cases argued at the High Court by ACLJ Chief Counsel Jay Sekulow. This free speech victory 25 years ago today set the course for what would prove to be a tremendous track record of success for the ACLJ in protecting your religious and constitutional freedoms. None of this would have been possible, though, without your prayers and support. As the ACLJ embarks on the next quarter century of defending our faith and families, take a moment and stand with the ACLJ. Your support is crucial and enables Jay Sekulow and the ACLJ to engage the issues that matter most to you and your family. Call right now, 1-877-989-2255. That's 1-877-989-2255 or online aclj.org.
Hey, welcome back, everybody. It is 25 years ago, it was today, that the Supreme Court of the United States issued our decision in our very first case that I argued at the Supreme Court of the United States in Board of Airport Commissioners versus Jews for Jesus. It was a unanimous decision. The case involved literature distribution around airports. It was an evangelism case, set the stage for a lot of other evangelism cases. We shot this little special piece we put together, which was my reflections on the Jews for Jesus case. Let's go to the special report.
Well, that was the first case, Jews for Jesus, and I had never been inside the Supreme Court of the United States until 3 weeks before I argued that case. I was at a board meeting at Jews for Jesus. I was on the board at the time, and the executive director said, we've got a case. The Supreme Court had just granted review. It was about literature distribution at airports, evangelism at airports. The Ninth Circuit had allowed the evangelism to take place, but the Supreme Court had accepted the case for review, and the thought was that they were going to reverse and not allow evangelism to take place.
The case is called Board of Airport Commissioners of Los Angeles versus Jews for Jesus. That case has affected every airport in the United States, opening them to personal evangelism and literature distribution.
I looked at all the cases involving religious distribution of literature and what's called the Free Exercise Clause of the Constitution and how it applied to religious evangelism, and basically our side lost every single time. So maybe it was just me being naive in this sense. I said, you know, that area of law is not worked out very well, this whole free exercise issue. Let's approach this a different way. If this was a union organizer wanting to distribute literature at the airport for union organization, would the Supreme Court of the United States say, no, you can't do that? Of course not. Of course they would allow it. Well, then why would it be different if it was religious speech? And then I came up with this idea of let's argue these cases as speech cases, not simply a free exercise case. So when I went to the Supreme Court of the United States, my entire pitch in that case was this case is about freedom of speech. And I barely mentioned religion in the entire oral argument. 9 justices of the Supreme Court, the most conservative and the most liberal, agreed that that resolution for the city of Los Angeles, which said no First Amendment activities at the Los Angeles International Airport, all 9 justices agreed that, in fact, that was unconstitutional. So it was a huge win for religious free speech. Probably the most significant win that we'd seen in 50 years.
Was a very big case at the time because there was a novel approach to it. Rather than arguing that the case involved the free exercise of religion, which is traditionally how the case had been argued, I asserted that religious speech, distribution of literature, sharing the gospel, was protected just as pure speech, that religious speech was no different than any other form of speech and should give the same protection, and that these airports were forums for free speech with all the commercial activities that take place there. It was a very interesting argument. It was my very first one. The audio here, and our guys have done a great job of cleaning it up, but it's 25 years old, as you can imagine. By the way, we're asking that you consider making a donation of $25 or more to the ACLJ in honor of that anniversary. We also have available, and when you call in, you can get information about this, our Supreme Court audio files, which are all of the arguments that I've had at the Supreme Court of the United States. You can find out how you could get those as well. So we encourage you to call us at 877-989-2255. That's 1-877-989-2255 or aclj.org. Now, a little bit of history here. Let me set it in motion for you here. We had no staff in those days. It was me and Pam. And Jordan and Logan were really young. The one thing we still have from that time period is the actual table that when it was Case, when the organization was called Case, where I wrote that Supreme Court brief, and we still have it right here. It's actually in our media center offices, but Jordan, you remember the famous table a lot. That's kind of become an icon here at the ACLJ.
Yeah, absolutely. It reminds us, talking to people on over 800 radio stations right now, where it all started and how young we were. And when the donation letters would come in from our supporters, we opened them all together. And Mom was writing the newsletters by hand. The whole the growth of the ACLJ in not that long of a time. I mean, 25 years. And now what we're doing here in the United States and also all around the world, able to help protect people's freedoms and liberties because of those early supporters. I know a lot who still listen to this broadcast every day.
Yeah, some are calling now. By the way, if you want to talk to us, if you remember those early days of Case or the ACLJ in the early days, give us a call. Before we go to the calls, though, let me play for you something here from the case. Now, our argument was twofold, that there was this public forum for free speech. That was the argument I made. I got a lot of questions from both Justice White and Chief Justice Rehnquist. Take a listen to number 5, and then we'll go right to 6.
Our position is twofold, that by tradition, if you will, that a public forum has been created.
So it's like a sidewalk, they just can't...
Yes, a sidewalk or a street or a park.
Yeah.
Well, how has it been created by tradition if airport authorities close them?
Well, the tradition, Your Honor, is...
I mean, what is the tradition with respect to major airports?
Major airports, as we know them, are a recent phenomena. They've not been. Their history is limited.
So there is no tradition with respect to major airports.
Your Honor, I think that...
Is that true or false?
I think there is a tradition, Your Honor.
What is it?
I think it's twofold. The first part of the tradition analysis could be that in a limited history, there is a history, though, First Amendment activities in the Central Terminal area at LAX have taken place. Jews for Jesus has been distributing religious literature for over 12 years now. And the other history...
That is the tradition, what's happened in the past 12 years?
Considering the length of the history of the airport itself, that period of time is substantial.
One thing I do notice, I since that argument, I do put a note to myself to talk slower, but I sure was moving quickly. But that was the nature of the kind of questions you get at the Supreme Court of the United States. First case I argued at the Supreme Court, folks, it was the first case I argued in a court of appeals, was at the Supreme Court of the United States. 9-0 in favor of Jews for Jesus and their right to distribute literature. And folks, in those days, there was it's a completely different communication situation then as it is now. One thing has not changed. The intensity of Supreme Court arguments, though, let me tell you, we got into a discussion about the history and whether this was a public forum for free speech, whether free speech could be banned. I'm going to play for you number 7 and 8. You're going to know this name is Justice Scalia, and you will hear he's always and still is 25 years later pretty funny in the courtroom. He's a brilliant guy and has a good sense of humor. Listen to 7 and 8.
We would further argue for a history in this case, one looking at transportation centers generally. City gates, we've argued this in our brief, the city gates from the period of Scripture have been places where people have come to hear ideas. It later moved to railroads, the waterfront, and now airport terminals. Our position is
I thought about that city gates thing. Do you really think that the analog is the city gate, or wouldn't the analog be to go back to the time of the Constitution, wouldn't it be the inn at which the coach would stop to pick up passengers, and they'd all assemble there and sit down in the dining room and eat a piece of mutton or something? Were Jews for Jesus allowed inside these inns, or proselytizing groups? Do you think so? They were private operations, weren't they?
Well, Your Honor, I think in the spectrum of history, if you will, if you want to start from the Constitution, our position would be, not being there, of course, that Jews for Jesus would have had the right if, in fact, it was not a private enterprise. We're not saying that all places are public forums. Everybody can go everywhere for First Amendment activity.
No,
So there you have a kind of a sense of what was going on this was my first oral argument, folks, and you see the intensity of the questions. I've got time to play this. This was my opponent in the case was named. He was an attorney for the city of Los Angeles named Capel, and he made an argument that these were not open for free speech. We're going to get to that argument, but he had a testy exchange with Justice Thurgood Marshall. I don't have time to play. I'm going to play. Well, I'll tell you what. We do have time to play it. This is my opponent, and then Thurgood Marshall starts at number 16.
What is wrong with what these people do?
Nothing is wrong with what they do.
How can you prohibit something that doesn't do anything wrong?
Because we are trying to control the uses of the interiors of the terminal facilities. The mere fact that it is not wrong does not mean that it is airport related and is the best use of the terminal facilities.
What right do you have to stop it?
I believe the board has the right to limit the use of its facilities to their intended dedicated purposes.
Could it stop all red-headed people from using it?
Absolutely not.
Why not?
Because I believe that would be discriminatory.
Why is this discriminatory? You're singling out one group of people.
Well, there you have it. I mean, how you couldn't be any clearer than that. One group of people being singled out. That was Thurgood Marshall. By the way, after that little exchange, I felt pretty good about the case, though you never know until the decision comes out. Hey, folks, what we said, ACLJ.org. I want to encourage you, go online, make a $25 donation today. It's in honor of this 25th anniversary of this case. We'll be taking your calls as well. But let me also encourage you can call us right now, pledge that $25. You can also get the audio of all of our Supreme Court cases. Those that are answering the phones can help you on that. ACLJ.org is a great way to make the donation, or call us at 1-877-989-2255. ACLJ.org or 1-877-989-2255. Back with more from the 25th anniversary of the Jews for Jesus case when we come back.
It was a resounding win for free speech and religious liberty. 25 years ago today, the Supreme Court, in a unanimous decision, agreed that religious speech must be given the same protection as all other protected speech. It was the first of what would be many cases argued at the High Court by ACLJ Chief Counsel Jay Sekulow. This free speech victory 25 years ago today set the course for what would prove to be a tremendous track record of success for the ACLJ in protecting your religious and constitutional freedoms. None of this would have been possible, though, without your prayers and support. As the ACLJ embarks on the next quarter century of defending our faith and families, take a moment and stand with the ACLJ. Your support is crucial and enables Jay Sekulow and the ACLJ to engage the issues that matter most to you and your family. Call right now, 1-877-989-2255. That's 1-877-989-2255 or online aclj.org.
Welcome back to the broadcast, everyone. Well, Jews for Jesus was the start of our cases at the Supreme Court of the United States that involved evangelism. The second case we had, major case at the Supreme Court of the United States, also involved free speech and evangelism. It involved schools. It was called Board of Education versus Mergens. Well, that case went to the Supreme Court of the United States, an 8-1 victory for the students. That's the case that opened up Bible clubs throughout the United States. Let's take a look back.
The turning point for religious liberty in this country was clearly the Mergens case involving Bible clubs, because it set a different tone. It said no longer will expressions of faith be removed from the public school as if they were somehow subversive or against each other. And that changed the way people thought about religious practice and religious faith, not just in schools, but then across the board.
We wanted to have the Bible study meet in the school, and we thought it'd be no problem to start. But it turned into a problem when the principal said, no, you can't have it.
They may not meet under the present ruling of the Court of Appeals for the Fifth Circuit if that speech involves some sort of religious thought.
Is it a freedom of speech question in your opinion?
It is not. No, sir. Do you think that high school students and grammar school students should have equal rights with college students?
Do you?
No, sir.
They have the right to meet, and they should have the right to meet, because this is a democracy.
The public schools are really no places for religious meetings, for masses, for revival meetings, for prayer meetings.
Congress saw this widespread discrimination, and that's what it was, against religious speech, Christian speech in particular. They passed in 1984, after extensive hearings, the Equal Access Act.
All it does is say that if a school allows a Young Republicans Club or a Kiwanis Club to meet, equal treatment must be given to religious groups.
There was like a sealed door, which was keeping any practice of, any expression of religious thought out of the schools. There's one ruling after another we can cite, one case after another. Now that seal has been broken. That's the big thing. This is more than a foot in the door. This is an epic change.
Bridget Mergens stood before the school board and asked that she be allowed to have a prayer club and a Bible club meet on her public high school campus. And they were denied that right, even with the Equal Access case. In 1989, when they made the request to the Supreme Court of the United States, and the Supreme Court said, yes, we're going to hear the Mergens case.
On June 4th, 1990, the United States Supreme Court issued a landmark decision. 8 of the 9 Supreme Court justices ruled in favor of Mergens.
And everybody said, when we went and did that prayer and Bible club case, there was no way. That's what the world said, that you'd have prayer and Bible studies back in a public school. No way. And then the decision came out. And it wasn't just a little victory, it was 8 justices out of 9.
What does that say? God answers the prayer of his people.
If you're just joining us, we're celebrating the 25th anniversary of our very first Supreme Court decision. It was unanimous in our favor in the Jews for Jesus case. It was 25 years ago today as we're taping this broadcast for our television audience, and for those listening on radio, it happened today. About 3 hours ago is when I got word by making a phone call on a payphone to determine that, in fact, the Supreme Court of the United States had, in fact, issued the opinion. Later that afternoon, I went out with the team at Jews for Jesus distributing tracts. I was near the ABA building. I'll never forget this, in the American Bar Association building, and some lawyer made some snide comment as he was walking in that building about the literature distribution and said, get a real job. And I said, well, I have one. I was the lawyer that argued that case that came out today by the Supreme Court of the United States, which kind of changed the nature of the conversation, as you can imagine. Talking about conversation changers, let me play for you an exchange. My adversary, my opponent, he was also an officer of the court, of course, Mr. Capel, was arguing about the concern with solicitors. This case wasn't involving monetary solicitation. Jews for Jesus never solicits money in public while they're out distributing literature. But the Chief Justice had a very funny response to this. It was very quick. Let's play number 14.
Much has been made of the presence of solicitors here within the terminals for 10 years or so. The only thing that shows is that the board has not had the appropriate tools to keep these people out and to enforce its policy. They have had it
like a good ordinance drafter.
Yes.
The reason that's significant is that the ordinance itself was declared by Justice O'Connor in the decision. She wrote the opinion as so overbroad that no conceivable governmental interest could justify such a sweeping prohibition on speech. So she was the author of that opinion. Let's go back to our phones. Jordan, who's next?
Glenn's calling in from Michigan on line 1. Glenn, welcome to Jay Sekulow Live.
Hi, Glenn.
Hey, congratulations.
Thank you.
25 years, Jay.
Yes, 25 years. And you were with the Liberated Wailing Wall.
Yeah, in fact, we were in Chicago that very week, going through the same training with you guys. Yep. And I remember how nervous everybody was. And in a real sense, because of the nature of legal precedent, taking the L.A. airport on could have set a
right.
precedent against all evangelism. So really it was such a crucial court case, and thanks be to God that you won it.
It wasn't a case that was easy, though, and Glenn was kind of alluding to this. It was a precedent center because of the free speech aspect of it, and we had to argue aggressively on this point that this was a speech case and there was a lot at stake. And Justice Scalia was pretty aggressive in the oral argument, although he was part of the decision here. But I want to play number 10 and 11 for you, and it kind of shows you the nature of it. And by the way, he's not any less aggressive 25 years later. Take a listen.
Can you think of any place where it wouldn't be compatible? Let's say the Capitol, right across the lawn there. Couldn't you set up little booths for, various groups that want to pass out literature to the tourists coming? Would that interrupt the?
That's a factual analysis. There conceivably are.
I think it wouldn't, but Congress just says we don't want it here.
There are other.
This is not what the building's for. We don't want it. We could live with it, but we don't want it. Why can't the airport say that?
Well, the airport is taking a position that they have said that. However, it is that accommodating purpose, the contemplation of being able to hand out or distribute religious literature in this case, where it does not at all interfere with the efficient operation of that facility. If, in fact, the outside of the Capitol area was appropriate for distributing literature, as the situation with the sidewalks in front of this court's facility,
that's your test. If it's number one, a public area, and number two, it wouldn't interfere with the public purpose.
Substantially interfere.
Substantially, the activity must be allowed.
Your Honor, it would be a balancing test. If the compatibility is there, yes. We would assert that if, in fact, the First Amendment activity is compatible with the forum's use, and there's this general open access, that, in fact, a public forum has been created.
So there you have it. I mean, that gives you can see these are, Jordan, you've been to a lot of my arguments since as an adult or even as a teenager. It hasn't gotten any less. In fact, folks, the expectations, because I've been back by God's grace so many times, the expectation's actually higher.
I can tell people from being there and watching my dad do this intense. If you think any of those Fox News debates are intense, it's nothing compared to what goes on at the Supreme Court of the United States.
I think that's a very fair and very accurate analysis. Jordan will also tell you that these cases that we're talking about, he studied in law school. I mean, these are textbook cases now in the law books.
Yeah, absolutely. Just about every single one of these cases on religious liberty, defining religious freedom as free speech, and some of the precedents that were set, a lot of the law school professors, liberal and conservative, point to you, Dad, because of the decision to say that, if they don't want to make religious and the free exercise of religion mean anything anymore in the First Amendment, which they basically had already eviscerated at the Supreme Court before you started arguing cases, why are we just talking about it as religious speech? Isn't it just speech, freedom of speech protections? And that fundamental point is what changed the case law. If you look at the 60s, 70s, and then start looking into the 80s and 90s, when we started racking up all those victories at the Supreme Court.
All right, let me play one more for you here. This is Justice Marshall. It's number 12. He had a series of quick questions for me as the argument progressed. Listen to it.
LAX passed a rule that you people cannot go beyond the metal detector, and only those who are riding go beyond the metal. Would that be a good rule?
If, in fact, the general public was not allowed access past the security point.
I said nobody but riders.
I think, Your Honor, an argument can be made that the First Amendment activities should, if you will, that should be the line of demarcation. That should be the stopping point.
It could be made or would be made. You say could be made. You can argue that building's a cat. But I mean, would be made.
Well, Your Honor, I would say that there is a line, and that would be an appropriate place.
How far you go?
You have to add a factor to that, Your Honor, and that is, are there other activities taking place past that security point?
See, the reason I'm glad we played that clip, because it shows you got to be very careful. They tried to back you into a corner of line drawing, and the security line was the easy one, but then he was adding facts to it. Thurgood Marshall was always a pleasure to argue in front of, as were all of them. It's been one of the great honors of my life, being before the Supreme Court of the United States. It's certainly an honor and something I cherish, and I'm very appreciative. Folks, that's going to do it for our broadcast today. Thank you for our television audience for being with us. It flew by, but it was great to hear from one of the staff guys at Jews for Jesus. That was great as well. Folks, here's what we're asking you to do. Go to ACLJ.org. Let me encourage you to make an online donation today to support the work of the ACLJ. $25 is what we're suggesting because today is the 25th anniversary of the decision. You can call us at 1-877-989-2255. That's 877-989-2255. Or simply just go to the website at aclj.org and make that online donation of $25 today, tax deductible, of course. Let me also say to all of our friends, members, and partners that are out there watching this broadcast now on television or listening to us on radio, thank you. We could not go to the Supreme Court of the United States without you. I also want to thank Pam, my wife, Jordan and Logan, my daughter-in-laws as well, for standing with us in these great and important fights, and we'll see you next week.
It was a resounding win for free speech and religious liberty. 25 years ago today, the Supreme Court, in a unanimous decision, agreed that religious speech must be given the same protection as all other protected speech. It was the first of what would be many cases argued at the High Court by ACLJ Chief Counsel Jay Sekulow. This free speech victory 25 years ago today set the course for what would prove to be a tremendous track record of success for the ACLJ in protecting your religious and constitutional freedoms. None of this would have been possible, though, without your prayers and support. As the ACLJ embarks on the next quarter century of defending our faith and families, take a moment and stand with the ACLJ. Your support is crucial and enables Jay Sekulow and the ACLJ to engage the issues that matter most to you and your family. Call right now, 1-877-989-2255. That's 1-877-989-2255 or online aclj.org.